Infiltration, which was a very major problem in Jammu and Kashmir, reduced by 90.2%, 90. Law and order events, substantially the stone pelting and other events, reduced by 97.2%. These are all figures relevant for the purpose of decision.
Minister, this is not for our purposes really relevant. We only want
No, for the purpose of when to hold the election. As on date, this is the position. That's what I am pointing out, and these are, everything is on affidavit. I am not. And security persons casualty is 60 reduced by 65.9%. These are the factors which agencies would take into consideration. But fortunately, affected the elections most were stone pelting incidents and regular call of Bandh or Hartals, means hospitals, schools, every institution where a common man is concerned. From 2018, in 2018, the stone pelting was 1767. It is nil now. Not just because of effective policing or security personnel, but because of various steps, like gainfully employing the youth, etc. They were misled by the secessionist forces, by the forces outside the country, etc. And organized bandhs, which were in 2852 instances, organized bandh, call of bandh by secessionist forces. Nil.
How many?
In 18, they were 52. Now, it is nil. Now, Lord, so far as statehood is concerned, Lord, I have already made a statement before your lordships, but that apart, the statement of the Honorable Home Minister on the floor of the House, that UT is a temporary phenomenon. We are dealing with an extremely extraordinary situation. The state will have to be infused with several things so that it becomes a state, so to say. Lord, those actions, my Lord, are initiated, and Lord, I may give some, my Lord, instances how it is progressing, my Lord, to become a state, because I am unable to give, my Lord, exact.
You can wrap up in about 2 minutes now.
I'll just, my Lord, give me 2 minutes. Your Lordship did not write. I'll place it on record. Lord, for the purpose of ensuring that the UT becomes complete state, my Lord, as it should have been like any other states, the central sector scheme investment is 28,400 crore. The investment proposals from other than central schemes is 78,000 crores. And till date, the actual investment made is 2,153 crores. Your Lordship did not write. I'll write it down, and, my Lord, and give it to your Lordships. Lord, several initiatives have taken place, and as a result of which the transparency, Lord, has shown us that the projects have risen from, and these are all, my Lord, statements on affidavit I have made, 9,229 in 2018, and now in 2023, it is 92,560. More and more people are participating in e-tendering and several e-initiatives, my Lord. And therefore, my Lord, that is also giving a boost, and the youth is gainfully employed. My Lord, the peace doesn't come merely by police action. There are several schemes which are introduced, several beneficial projects which are introduced. I'm just giving a bird's eye view, my Lord. And out of 53 projects under the Prime Minister Development Package, worth 58,477 crores, out of 53, 32 are completed. This is how progressively, my Lord, we are proceeding to make it a complete state. But I am unable to give, my Lord, my instructions are the exact time period right now about the complete statehood, while saying that union territory status is a temporary status. Because of the peculiar circumstances the state had passed through with repeated and consistent disturbances of decades, well, it might take some time, and we have shown, my lord, the progress also. My lord, it was heartening for me also to note that only in 2022, January 22 to December 22, 1.88 crores tourists visited. The lordships are aware, the main industry so far was tourism in Jammu and Kashmir. Now, my lord, industries are coming. And till date in 2023, 1 crore tourists. It gives employment, it generates employment in various sectors. My lord, one, there is a tourism boom. So these are the steps which are being taken by the central government, which can be taken only if there is a union territory. And I have shown the Reorganization Act. It is having all trappings of the state. But the election, the government is ready. It is for the Election Commission of India and Election Commission of the state to take the call. Out of three, which election to take place first and how. The updating of the voters list is complete. Some part is missing, my lord, but it is yet to be over. It's in the process. It would be over, my lord, in a month or so, my lord. That's what I'm told. Thereafter, my lord, they will take a call considering the overall situation.
Said once.
So you'll be wondering what the Chief Justice is doing is on a phone from the courts.
Yes. This is my expression. Learning assistant.
But I just want to know whether your lordships are taking into account these facts, because whether that's extremely relevant from our point of view. Because if your lordships had said earlier that subsequent facts will not be taken into account, we are dealing with the law, we are dealing with these facts.
Mr. Sibal, these facts on what they have said would have possibly no bearing on the constitutional issue which has been argued.
But even otherwise,
But-
because we have to counter those facts, Mullah.
We had asked them a question on the roadmap for holding an election.
That's fine, Mullah.
That's what they have responded.
But Mullah,
That's not, Malad, in my
That
argument
has-
on merit.
But our decision on the constitutional issue has to be on constitutional.
But Mullah, these facts will go into the mind of the court because they are trying to show as to how this enormous change has taken place for the benefit of the people of Jammu and Kashmir. If you have 5,000 people under house arrest and 144 throughout the state, there can be no one. So Mullah, my request to your lordships is, please don't enter into this arena because we will have to counter it with all kinds of facts, Mullah, which I don't think is necessary for this court.
The nature of the development work which the government says has taken place post August 2019, this may not be of relevance to your constitutional challenge. And therefore, when they respond to the constitutional challenge, that has to be dealt with independent.
I didn't rely upon it while
But
answering on
these
merit.
facts, if they come into your lordships, Mullah, as part of the record, then that has.
I think, Mr. Sibal, what the solicitor, to be fair to the solicitor, what the solicitor was saying is that the roadmap to full statehood would take a little time.
That's obvious.
Right now, that they are the development. There, his submission is that right now development work is taking place. Some stability has to be brought about. This is not a permanent arrangement, namely the UT status. They envisage that it will be a movement from UT to statehood again. We can't give you a fixed point of time when we will restore statehood, but they have told us the process which they are following on the path to. Full
I have
statehood.
no objection to
That-
that statement. I have no objection.
And that's how we read it.
Yes,
actually.
well, if any other fact that you bring to your lordship's notice has no bearing, because I'll have to
Mr.
counter it.
Solicitor, Mr. Attorney, we take it that what you said, Solicitor, a short while back, is along the lines what we said.
Yes, yes,
That this is-
answer the election and
The roadmap to
statehood
full-
query, not as a
Correct. I have
justification
no
for.
problems to that,
Mr.
Mullah.
Sibal also fairly says that he has no difficulty about that.
During my arguments on merits, I never relied upon.
This cannot be an answer to the constitutional challenge.
But even otherwise, it should
I
not
also,
speak
Mullah,
into your
didn't,
lordship's
I
mind,
would-
Mullah, that these are great things that are happening, Mullah, because today, the kind of drugs that are happening with the youth in Jammu Kashmir is unbelievable. But I don't want to enter into that controversy.
Can I put it like this?
The
Neither,
unemployment rate is enormous.
Mr. Sibal, these are matters on which there can be and should be in a democracy policy differences,
That's right.
but that can't affect the constitutional
Absolutely.
answer to a constitutional
Therefore, Mullah,
challenge.
once you start placing these facts and Mullah, your lordship.
But therefore, we place those facts which he mentioned in the perspective of the roadmap to statehood, that's all. And nothing on.
This is
on
not
the-
a justification.
This is not a justification, it is, cannot be, from our perspective also, to the answer to the constitutional challenge. We'll have to address the constitutional
So your
challenge. on
lordship will
constitutional
allow me to
grounds.
place some counter facts to that?
may I
it's
put
not
it like this?
necessary,
But
Mr.
I had intervened that stage also when you were saying, only for this reason that we wanted in a conspectus to understand when they look to a restoration of statehood.
No
To
problem.
which they made a statement that
That's no issue, Mullah. They say that will take some time. Your lordships will decide on that issue, Mullah.
And that's confined to our answer, our question to Mr.
But
Solicitor.
Bunds
Yeah,
have
very
been
clear
reduced to
on this.
zero, bunds have
Neither-
been reduced to
but-
zero, all
but-
that,
don't
much.
mind.
With respect, I say, your lordship should not even, those facts are not relevant for the purposes of your lordship's decision is all that I
And
say.
therefore, we had not taken that additional affidavit which was sought to be filed at the inception of the record. And I don't think there's been any change in that.
Thank you.
position.
I think it's better understood like this. Neither these statements nor their refutation, if need be, will enter into the question of determining the constitutional validity.
Correct.
So therefore, paraphrase it like that.
Yeah.
You don't want to put it like
And
that.
on that
Kindly
aspect,
see.
I also
on
didn't
that,
rely.
on that,
Kindly
Mr.
see.
Sibal, Mr.
It's for an
Attorney and
entirely
Mr.
different
Solicitor,
purpose.
I think there's a broad-based understanding on both sides that the constitutional challenge has to be answered on.
But
a
During my assistance on merits, I never relied upon
The
this.
problem is the following, these are televised, all this is being televised and all of this being recorded. So Mullah, these facts come on the record, they are part of the public space. and people feel what a great thing has been done by the government, well, this creates a problem. Well, that's why I.
What's why, progress never creates problem.
I'm sorry.
Lack
Please
of
allow me.
offenses
All right,
do not
Well, we
create
got the
problem.
point. We got your point. I think we have clarified it.
Yes.
That the constitutional challenge will be dealt with by the Supreme Court on constitutional grounds.
That's right. None of this should enter into the.
And they have not argued equity in defense to your constitutional
That's all,
challenge.
that's all, Manu, that's all.
Yes.
I suppose these statements are otherwise in the public domain. In elections, will
lot
be-
in the public domain.
And therefore,
Mr. Attorney,
public
there's a
will
lot-
consume it.
Mr. Attorney
because-
General, you're meeting the constitutional challenge on constitutional argument.
Which I
We
did.
must
I never-
address this matter like any other constitutional
That's-
matter as a
that's right. In the
constitutional issue
public-
which we have to
I can
confront.
raise a lot of facts.
But when I answer the question of election and the statehood, these figures will go into our
So
decision.
that you may, that's not part of the public space.
And that
You-
Mr.
then
Sibal
you-
has also clarified, there can't be any.
That's
objection.
internal-
We needn't labor this issue, we are all now clear
Yes, yes.
on conceptual grounds. Mr. Attorney, now we'll hear you.
Please, Your Lordship. And one is reminded of Dworkin's very deep engagement on the hard cases and not one single.
Only
Yes,
one
yes, yes.
interruption, Murad, on the lighter side. My learned friend said that there are some people who are under house arrest and therefore there is no bond. Well, that means the right people are in the house arrest.
5,000 people. Let's not make
Isn't it that-
let's make a mockery of democracy.
People are under house arrest.
5,000 people were under house arrest at that time. 144 was throughout the state. This court, Manadina judgment has recognized that. Well, the internet was shut down and then they are saying there were no buns. Why, how can there be buns when people can't even go to hospital? People could not go to hospital because of the bun.
I
They
wish-
died.
I wish,
A single.
Let's not go into all this.
Mr.
I
Sibal.
wish we don't enter into
one
this
second.
dialogue.
Mr. Attorney,
I-
Mr. Sibal, we have, right from the inception of the hearing, we have heard this matter in a sense of dispassionateness,
Absolutely.
the sense of objectivity which must govern an answer to a constitutional challenge. We request both sides. Let's maintain it at that level.
Absolutely.
Because, yes. Yes,
I don't
Mr.
think
Attorney.
neither the solicitor nor me has entered into the domain to try to color the mind of the judges. We've not done that. I don't know about that.
All right. Yes, Mr. Attorney.
As I say that the famous principle versus rules and the hard cases thesis of Dworkin, one wonders we are not in a situation like this. We're leaving, taking off from what, where I left day 4 yesterday. There's a couple of digressions I would like to probably play before a lot before I. Because when you talk about the intent of a law, Wittgenstein, who co-authored with Bertrand Russell, and his famous philosophical investigation, he talks about a signpost. How do we know what a signpost means? There must be a practice of using the signpost. And an understanding which develops over the using of the signpost. Without that practice and understanding, the signpost means nothing. So this principle has been used in various circumstances to bring closer. If there is an understanding about a law on the basis of a practice, then interpretation follows one course, one trajectory. But if there is a lack of understanding or conflict of understanding, interpretation heads in another trajectory. Therefore, when we are trying to understand the intent and connect with the content of Article 370, you have to keep in mind what went into the original author's making of 370 and what has happened over a period of time by the practice of using Article 370. So, a text sometimes, by reason of its aging and the use of the text, may demonstrate a certain practice which may show in a slightly different direction. That's why in the context of desuetude, two important principles come. A disuse plus a contrary practice. I don't get into the desuetude doctrine, it's not necessary for a purpose. I don't want to flag that. When you're trying to understand 370 in a perspective, we have all these complexities. It's not really a case of reading the text, looking at the text and the context, and arriving at a meaning. We are confounded by the practice of Article 370, whether in conformity with the original intent or in deviation from it. So the court is now called upon to look at the age of the text and the use of the text, and how in current times the president understands both the original text and the use of the text, and the president now understands this is what I would like to do with the text. I left day for a study on this proposition when the president is not precluded for what I call the taking stock of what Article 370 has done over a period of time. This taking stock is written into Article 370. While we do that, how the president may take stock and how the court will be called upon to have a glimpse of understanding of what the president intend to by taking stock. I just want to place 5-6 propositions in the context of construction against absurdity. These are all gathered from books on interpretation of statutes. Because the presumption against absurdity will, number one, avoid an impossible result.
Presumption.
It will also avoid an unworkable or impracticable result. I'll put them all together and hand it to your lordships now. It will also avoid an anomalous or illogical result. And connected to that is to avoid a futile or a pointless result.
What is the third one you said, Mr. Attorney?
First one is
No,
an impossible result.
no, third one.
Third one, an inconvenient result. An anomalous or illogical result. An anomalous or illogical result. The final one, I said a futile or a pointless result. All these will go into courts looking against the presumption against absurdity. So court will avoid a construction that requires the person to do that which is impossible. The doctrine of impossibility is contracted is different, but when it comes to textual impossibility or constitutional text, it may stand on a different footing. That's why all these principles have a certain importance in construing Article 370. I referred briefly the other day about this presidential poll judgment of your lordships. That is 1974 to SCC 33. Before I take a lordship that
What's the name of the case?
1974, it is a 143 reference in the context of holding election. Before I take your lordship to that, let me make a few observations.
No, that's good.
It's not part of the PDF because it's not part of the compilation. Sir.
Yes.
So we are trying to look at the proviso to clause 3 of Article 370.
So which is the part of this judgment you want us to see? Para?
I'll give the paragraphs, your lordships.
We have it opened up and you have it on the screen.
Yeah,
as well, sir.
we have paragraphs. I'll just summarize the proposition was the presidential election had to be held. Gujarat Assembly was dissolved. Therefore, the electoral college was incomplete. So the argument was without the electoral college becoming complete, you can't hold a presidential election. Court says I read Articles 55, 54, etc. and come to a conclusion. It's a mandate that you must hold the election before the president term expires. Right. Therefore, the lack of the electoral college not being complete will not come in the way. So that unless you fulfill that impossible, that the court says you must, the argument was, you must have the electoral college completed before you hold the elections. For the
So
mandate of holding the
trying
elections.
to- You're stretching that to our case because according to the conditions for the application of the proviso to Article 373 are absent. And therefore, the substantive part cannot be rendered into disuse merely because of the
You're
absence of the
absolutely
Constituent
right.
Assembly.
Therefore, I come to the argument on the other side currently. Now, there is no principle in
What's the para?
jurisprudence.
Just give us that small para so we are then done with this judgment.
These paragraphs 5, 4, 5, 12, 13, 15, 20, 21, 29, and 47. So there they look at the impossibility of performance.
How
So what I'm
do
trying-
they formulate it? Just let's see it in a moment.
I'll presently come to it.
It's 7 judges, so we can just look at maybe that one or two sentences and how they formulate it.
Give me paragraph. You also just see paragraph 4 and 5. Paragraph 4, page 47 of the running page 47 of the judgment. They come to a conclusion that the conclusion part of paragraph 4, it shows that the time to hold an election to fill a vacancy is also mandatory in character. Then,
Actually, the
paragraph 15, that's important for our purposes.
Some of this suggests so let's take it to
Page 49, running page 49 of the judgment, paragraph 14, last sentence, and then thereafter paragraph 15. Paragraph 14, the last sentence. Sentence beginning, the necessity. Justice Collins got that paragraph.
Only 26 pages.
stop you from. Strike all that.
Paragraph 14, last
49, page
sentence.
49, page 49.
the sentence beginning the necessity for completing the election.
14.
Yes.
Before the expiration, the term is enjoined by the Constitution, public and state interests, and to see that the governance of the country is not paralyzed by non-compliance with the provision that there shall be a President of India. Next paragraph. The impossibility of the completion of the election to fill the vacancy in the office of the President before the expiration of the term to office in the case of so-and-so, as may appear from Section 7 of the 1952 Act, does not rob Article 62(1) of its mandatory character. The maxim of law impotentia excutat legem is intimately connected with another maxim of law, lex non cogita impossibilia. Impotentia excutat legem is that when there is a necessity or invincible disability to perform the mandatory part of the law, that impotentia excuses. The law does not compel one to do that which one cannot possibly perform. So I cannot possibly resurrect the Constituent Assembly and say, I want your opinion on this matter. So therefore, when it appears that the performance of the formalities prescribed by a statute has been rendered impossible by circumstances over which the persons interested has no control, like the act of God, circumstance will be taken as a valid excuse, so and so, etc. So it has two aspects. One, you are relieved from performance. You are also relieved from performance the way it commands you to perform.
Say it's like an.
Yes.
29. Paragraph 21. An argument that it shall not be done is available in paragraph 21. Paragraph 21. The interveners submitted that the units of the Electoral College were House of Parliament and the Legislative Assembly of the state. Johnson submitted that the democratic character of the Constitution demanded that there should be elected members of the Legislative Assembly of the states to be entitled to cast votes at election. It was said that states were denied the right, they would be denied representation. It was also said that if the states were denied the right to cast votes at election, the parity between the states and the union would be disturbed. All that argument is considered. And kindly turn to paragraph 29. Again. It was said by the interveners that Article 54 reflects the democratic patterns of participation by the states in the choice of the president, and if a state were denied such a right, it would be undemocratic. Recourse was taken to Article 368 to show that Articles 54 and 55 are mentioned in the proviso to Article 368. And if any amendment of Articles 54 and 55 is required, consent of the states is necessary. It therefore said by the intervener in Articles 54 and 55 read with 368 would be a key to the interpretation of Article 62 that no election of the president could be held without the representation of the elected members of the Legislative Assembly of the state where the Assembly has been dissolved. These submissions on behalf of the intervener are without substance. Then we go to paragraph 47, the conclusion. Can you also make a note of paragraph 33? If as a result of dissolution of a legislative assembly of a state, there are no elected members of a legislative assembly of a state, A state will not have an elected member of the state legislative assembly to qualify for the electoral college. It may be said in the analogy of the observations in the Karake Supra, there are vacancies in the electoral college by reason of the fact that there are no elected members of the legislative assembly of the state where the legislative assembly is dissolved. That matter will not be a ground either for preventing the holding of the election on the expiry of the term of the president or suggesting the election to fill the vacancy caused by the expiry of the term for the office of the president could be held only after the election legislative assembly of the states where the legislative assembly is held. So for the proposition, and then kindly paragraph 47, the conclusion is drawn. Paragraph 47 is at page 57, landing page 57 of judgment.
Yes, yes, Mr. Attorney General, we have seen that.
Therefore, we are trying to find out if falling back on the proviso is an impediment. Therefore, the president is deprived of the authority under clause 3 to go either way. Will that not do violence to the text and the intent of Article 370? So one principle in law is very clear that no text once enacted will efface itself out. We only know the principle of express or implied repeal. So there's nothing like, I have done my duty, therefore I exit the scene. Clause 3 still remains as an important part of reaching the exit stage. The only question is, how do you reach it? What is the more thorough way of reaching that exit stage? What consideration will weigh the president in exercising the power under clause 3? One possibility is, maybe it's extreme, to say that because the Constituent Assembly is no longer exists, the proviso dissolves itself along with the Assembly. That's one way of looking at it. Suppose we don't want to go that route. Then the president could have said, I am free to exercise my power under clause 3 to bring to a close all of Article 370, subject to whatever other considerations the president may take into account. The other way is, should I try to follow a precedent set by the president earlier by recourse to Article 367 and recourse to Article 371D? So, extending any provision of the Constitution with modification and find out if I can possibly take the assistance of any body who can fit in within the framework of the Constituent Assembly. So in 2 occasions, the president has done that earlier. I'll come to those details. There are a large number of provisions in the Constitution, which Dhawan also tried to point out, non-legislative functions of the legislature. You pass a resolution, you pass recommendations. These are non-legislative functions. Recommendation power, a role assigned to the Constituent Assembly, was a non-legislative function. It's not a legislative function at all. Give the reference. Video page. And then we have a key in Article 356 1B, that after a presidential proclamation, the President can declare the powers of the legislature. It doesn't say the legislative function. He talks about a compendium of powers available to the legislature, and that the President takes over to hand over to the Parliament. For the sequence of events which is contemplated in a situation like this, where there is a void,
So non-legislative.
there is an impossibility of complying with the proviso to clause 3. How do I fill that void, if at all it's a void? I said the President could have said, without recourse to any other course of action, I could have myself taken decision on rendering Article 370 inoperative subject to modifications. But the President does not adopt that course. She wants to be guided by a process which will closely be approximating to the non-legislative functions of a constituent assembly. That is where the legislative assembly substitution comes in. Once it is the non-legislative power of the legislative assembly, under 356(1)(b), the Parliament can certainly say, I take stock of what I can do. And the Parliament recommends to the President, which then we see our CO 273. So therefore, there is a sequence in which President addresses, having regard to the magnitude of the problem, the importance of the solution to be arrived at, and the difficulties in handling these momentous issues facing the nation and J&K for a long period. So all these imponderables enter into the decision-making process by the President. Therefore, if a particular process is sought to be the best process, in order that any legal objection could be taken against that, is not taken. You may still find a hole in that. That's a different matter. That's how the sequence of events have taken place. So I don't find, therefore, if the doctrine of impossibility stars one on the face, you are not paralyzed. Clause, since Article 370, the author, sometimes I wonder poor Gopalaswamy Iyengar, we keep talking about his statements in the Constituent Assembly. We have traveled far beyond what he thought was happening. Therefore, if we think that clause 3 of Article 370 will undergo a natural death, I don't find any room for that to happen at all. So what happens today is, because of the age of the text, the long duration by which Article 370 has been used, rightly or wrongly, we have counsel for the petition saying we are reasonable authors of the text of Article 370. On the one hand, the original author, the original intent, and its practice over a period of time, which can be given a certain understanding in construction. On the other side, we are the reasonable authors of what we'll say about Article 370. But two schools of thought there. One which says 2 and 3 will efface itself out. The other says the whole of Article 370 will go, because after 1957, it can't serve any purpose. This conundrum of two reasonable authors entering into a construction as against the intent of Article 370 and its practice to be considered on an objective basis, having regard to the purpose which Article 370 was sought to be invoked at that point of time. So all that will enter into the construction of Article 370. So I say the President is not precluded from taking stock of all this. It's not really writing on a clean slate now. I mean, one has to take stock of what has happened over a period of time. You may have so many choice of action. You may have called upon to comply with certain mandatory requirements under the Constitution. You may have taken under Article 3 the view of the legislature. Very important mandatory requirements in ordinary times. But when certain other compelling circumstances which confronted the nation for a long period, the parliament, the president. So therefore, all those variables which enter into taking a final view on Article 370 has been taken in this manner. That's why I started saying about Lincoln, I quote from an entirely different perspective. It's not about end justifying the means. It's about taking stock of a very complex situation. Do we have a mathematical formula to do it? Or do you only measure it by saying there are constitutional mandates? If you disobey them, you breach them, then you can't follow any portion as regards Article 370? Or look at the future of J&K. I do not know whether these questions can be answered on any normative mathematical position through a judicial scrutiny and then weighed on various fine golden scales. Very difficult. So when Keshavananda Bharati has told us now, look here, don't breach fundamental features of the Constitution. Now it's become an integral part of our understanding of the Constitution. Therefore, we are told to go forward, say how the salient features of the Constitution and its functioning and exercise do not permit any deviations. Fair enough. But you look at the entire Part 18 of the Constitution, 352 onwards. And 352 occupies a very important place in the constellation of Part 18. External aggression, internal disturbance. So how do we have a mathematical yardstick or a criteria to say, this is how you will do it in the context of external aggression. This is how you will do it in the context of internal disturbance. You will have some fair, broad standards where fundamental values are not breached. But if there is something which you have to negotiate, even with the breach of some fundamental values, what do you do? Is it a political question or is it a pure judicial question to be answered in the basis of textual reading of the Constitution? That's what is confronting the court. But we are trying to assist the court and saying that you come as close as possible certain meanings which will advance the course of justice and understanding the scheme of Article 370. This maxim, impotentia excusat legum, has been applied in large number of circumstances in the field of contracts, in the field of legislations, so on and so forth. I'll give a few illustrations later after I then may take your lordships to go beyond this judgment. To submission. A few minutes. We have a mass of
What else? What more now, Mr. Attorney?
I may request Lordships to come to my written submissions and that's volume 4. Just want to place a few comments at this point of time.
What would be the PDF page?
Yeah. Volume 4. There's a separate volume.
Yes.
Internal
What
submission.
page? You were
Yes,
read up to a
page,
point, so.
PDF page 26. Couple of paragraphs from the submissions. I just want to make a small
Page 26.
observation that in the context of what I was trying to communicate to the court, looks at all those statements from Keshavananda onwards, for my in the 1977 resolution case, justiciability of the decision-making process. President or no president does not make a difference. If the justiciability will enter in the decision-making process. They were all cases of dissolutions of assemblies. Very narrow question of a dissolution of an assembly. But we went in a larger canvas. Lordship, please,
You're
sorry.
referring to the standstill agreement or something, so that is what page 26 is about.
Which is the para that you're referring to, Mr. Attorney? Because page 26, we have, the standstill agreement, as Justice Call said.
Yeah, page 26. I think it should be page 27. It begins at page 27. PDF page 27.
Idea of Article 370, its relevance and scope.
That's right, that's right.
Let's read through it. Let's see. Yes, we got
Page
it.
27. So before I try to convey this, that you try to invoke the jurisprudence of Bommai in a context like this, that could be a problem. As I said, there is a context of a resolution of an assembly. What factors go into it, whether they are relevant, objectively scrutinizable or not. But we are, as I said, in a larger canvas of taking a decision which has not only an importance for the purpose of looking at a part of the constitution to serve a certain purpose over a period of time, but looking at the future. So in all those cases, you're looking at an event which had a limited impact at a given point of time. We are looking at events which will have a far-reaching importance forever in the future. And for anything which is said in Bommai as conclusive in regard to judicial review, sovereignty, etc., I think may not be opposite. Let me not be taken to be understood that merely because there is too many complexities involved, the importance of the decision to be taken, and the impossibility dimension, etc., certain fundamental mandatory requirements of the Constitution can be slighted. I am not proposing that at all. But we are trying to find out if, without slighting them, if there is a way that has been adopted, or if it not been fundamentally breached, irreversibly breached. I'll come to that argument a little later. Therefore, the court will look at it very differently. So let me try to read a few paragraphs of my submissions here in 370. I have been trying to say this, that in paragraph 3, Article 370 envisaged a scheme of constitutional integration of the state of J&K with the Union of India, and thereby establish an interim system for the governance and administration of the state of J&K unit. A complete integration was achieved as was done in respect of other states. That's why much labor was taken by learned solicitor to tell your lordships. Look at the long history of what happened in the rest of the country. We all went through, many of them went through the process of constitutional ideas, constituent assemblies, a draft constitution, then comes Bierendorf's committee on a model constitution. So all that has been gone through in the rest of the country. So it is nothing new which has happened here. Only thing is having regard to the situation obtaining then, the external issues. Parliament thought, let us tide over it. How do you tide over it? We need a mechanism to tide over it. And we also probably inject into it a constitutional integration thought. That constitutional integration thought as the three aspects of 370, as I told you lordship yesterday, that I have set out in paragraph, just in the running sequence, under the same page 30, paragraph 9, the three dimensions of Article 370. So except the third dimension, namely termination, the other two dimensions have deep relevance to the constitution making process, constitutional integration process. So how will Parliament come and legislate before the Constituent Assembly takes a final call on what kind of a constitution we will have or a document we will have? So to enable Parliament to come in and legislate during that period, and once that is done, which has now become a permanent feature of the Constitution. So constitution making process was there in we have in Article 371 and 2 subclause B. So the other part is you extend the provisions of the Constitution. That's an equally important part of constitution making process. So once you extend the provisions of the Constitution, then what remains thereafter? So final constitutional understanding of what framework a Constituent Assembly will arrive at has to be aided and assisted by this process. Importantly, a fair element was drawn in consultation and concurrence. We're not in the point whether it's Sadri Riyazat, a governor, later prime minister, all those things are probably irrelevant. You're looking at the substance, not the form. If these are the three dimensions of Article 370, I would very respectfully say the termination of the role of Article 370, it could have happened any time. It could have happened soon after 1957. It could have happened even after when the Article 35 was introduced and somebody could challenge is what is happening in Article 370. Now that it has happened at some point of time, the termination has to be brought about in a particular way, which is the best and the most suitable way the President thought in the given circumstances. That's why I said taking stock to be an effective way of bringing it to a closure. I can't imagine anything out of thin air. I have to find out the best way available within the framework of the Constitution and the precedents available to the President, where Article 371D have been invoked, substitutions have been made. That's why I'm on pains to point out that when you talk of substitution of a Constituent Assembly by Legislative Assembly, we are looking at the non-legislative functions of the legislature as well as the Constituent Assembly. If the Constituent Assembly had recommended to the President before 1957, it would have done the same job. So if it could be done by any other equally competent body, now today first steps in the Legislative Assembly, and because there is a President rule, the Parliament steps in. To say that the Parliament is of a lesser paramount character than the Constituent Assembly in taking decisions for the nation's future. So, therefore, there is a weighing or a balancing may have to be a very, very difficult job. But my submission is, so the termination of Article 370 must occur at some time, notwithstanding whatever has happened over a period. And if the termination can occur in more than one way, whichever is the way which will advance the larger interests. That's why you look at the firmament of Chapter 18, Part 18 of the Constitution. I yesterday read out few parts of Chevrol's judgment to show that that the president, the exercise of power of the president is legislative and not executive. The governor's powers under the 5th schedule, powers under the 6th schedule to extend a parliamentary law to the 5th schedule area has been said to be a legislative exercise. So modification has been considered with several judgments to say it's a very wide amplitude. It's as good as sitting in judgment over the parliamentary legislation or the constitution. President is given that power to extend the constitutional provision with modifications, with that supreme authority given to the president. Yesterday I pointed out at page, PDF page 33, as part of Chevrolu's judgment. Middle of that paragraph, where it says, your lordships have that page of my. One sentence, application conforms to this. That's right. That's right. I just want to. Then let me take your lordships to few aspects of the recommendation. It's only to throw some light on that. Paragraph 12 at page 36. You can pick up any dictionary or any precedent on this question of nature of recommendation. There are a large number of provisions in the Constitution of India which uses the word expression recommendation. The context would be important. Sometimes it's a recommendation which can't be simply ignored or disregarded. Sometimes it can be binding. And by and large, the recommendation concept is to advise, to commend for action. All that few illustrations I have set out here in paragraph 12, I don't trouble your lordships with reading. I just only conclude this part of the argument by inviting Lord's attention to paragraph 18 of the submission that page, internal page 38. Neither the legislature of the state nor any resident of the state has any independent right in the continued retention of Article 370. In other words, beyond the constitutional integration process visualized to be completed, there was no other purpose of Article 370. As such, no person could claim the right of permanent retention of Article 370 as a permanent integration process. And the concluding observations are in paragraph 21, begins at page 39 and ends at page 40. And the last few sentences here, running to this page number 40 of the PDF. And that's right.
Let's read your conclusion, Mr. Atkinson, how you sort of sum it up.
So we are told that Article 370, by reason of its exercise over a period of time, is now open to several interpretations. And there's only one solitary interpretation, that it is to aid the constitutional integration process. Whatever has happened even thereafter will have to be seen in the light of that. If anything has, by way of deviation occurred, well, it is open to correction by the president. That's precisely what's happened now. The president says, I started saying, the president is not precluded from taking stock. The taking stock is inherent in Article 370. So if there is anything intrinsically which forbids the president to take stock of Article 370 and its exercise over a period of time, then one can understand it. But I don't think anything is available there. Therefore, I think it will open to the president to take stock of all the exercise undertaken under Article 370 and take into account the larger considerations which loom large before the nation, particularly the state of the case.
Yes, Mr. Anything else, Mr. Attorney? Now?
Your Worship. Not in record. We are confronted with just shifted the page. This part of it. Page. Sorry, navigating the system.
We are also navigating the time constraints, Mr. Attorney, now. So I think we can wrap up now, Mr. Attorney. If something remains, you can tell us after lunch if there's some thought which escaped your mind or something.
I would have done it very briefly now.
Yes.
I- to the code. I had a s- shared with the court. Some document I wanted to share with the court, I think it's missed getting into the court system.
Mr. Attorney, why don't we do this? We'll call upon the next counsel. You can come back to us after lunch if you're junior and you can
I
spend it
do
at lunch.
that.
We'll give you 2 minutes. There's no difficulty. So if there's some important thought that you have missed, we'll certainly not stand on the formality of concluded the argument. We'll let you again. So if there's something which remains, you can tell us in a minute after lunch, Mr. Attorney General.
Very well.
Thank you, Mr. Attorney. Mr. Sarve will be arguing
Yes.
after this. Yes,
I
Mr.
have
Sarve.
Short submission, ma'am.
to make, before I come back on that. My prepared. Yes. I thought we wanted to share a 2-page note with your lordship, but I think it didn't get into the system. Let me do it.
There's some thought which remains. You can come back after lunch. No difficulty.
Very well.
Thank you, Mr. Attorney
Very
General.
well.
Thank you. Yes, Mr. Sarve.
Yes. I have a few, okay, then I'll come back after.
Yes,
after
certainly.
lunch.
There's something, a point here or there which has been missed out. You can
Yes,
tell us.
I'll
We'll add
continue
it.
that up.
We'll add it.
Because there are a few observations I want to make on certain aspects. So can I continue thereafter? Yes.
Yes. Yes, Mr. Sarve.
Yes. My lord, I don't want, your lordship has heard this matter on both sides at considerable length. And the solicitor has, in great detail and with his customary meticulousness, ticked all the boxes and covered all the points from our point of view.
Appearing for in this matter, for the sake of the record, we must make a.
Yes, ma'am. I'm appearing on behalf of the applicant in IA 9573 of 2020 in petition 1099 of 2019. I have, my lord, for your lordship's convenience, made a 3-page roadmap of what I'm going to submit, if your lordships permit me to hand it over, so that it will be easier just instead of your lordship noting down.
Yes, Mr. Sarve.
Yes.
Has it been given to the court master already?
I believe so, my lord. Mr. Agarwal from. It has been sent, I believe, my lord.
अभी भेजने यार. You'll just display it for everybody because that way the other side also knows what your argument
Yes.
is. So therefore we take it as just an aid memo, nothing more.
It's like a skeleton of submission.
All right.
It's just It just sets out the points which I'm going to address, not what I'm going to say.
Just give us a moment, it will be uploaded so that
Yeah,
that way
not sure.
your learned friends on the other side also simultaneously
course.
can see what we have. So Shankar Narayan, you can tell Mr. Dhawan and Mr. Jha. They'll get it on the main screen as well. But I'm sure the main screen will also have it for. Hey, George.